Welcome to ProfDale's property video number 5. This one's entitled Interests in Land. This video is the first in a series of videos on estates in land and future interests. Here's a preview listing the other videos in this general area in case you'd like to jump ahead to one of them. But for now, back to interests in land. In this video, we're going to build a chart or graphic of interests in land. I'll show you the completed graphic at the end of the video, but I strongly encourage you to make your own. When we say interests in land, we don't mean, oh, this land is interesting. What we mean by an interest is a right of ownership that's recognized by our legal system. Now, our system recognizes only certain categories of rights, and they have strange names derived from the English common law. The chart we're going to build here will help you to learn the names. Here's a sneak preview of the entire chart we're going to draw, and of course you could at this point simply stop the video, do a screen print, and make a hard copy for your own use. But instead of that, I'd strongly recommend that you draw the chart yourself on a fresh piece of paper as we go through its various elements. The reason is that you need to memorize this chart, and that will very much help you do that. So to create your own chart, take a fresh sheet of paper and at the top write interests in land. Now divide your interests in land into two categories, estates and non-estates, because every interest in land is either an estate or not an estate. What do we mean by an estate? Well, most people have the concept that an estate is a big English country house with beautifully landscaped grounds. But that's not what we mean by an estate in terms of legal terminology. Now, the legal meaning of the term estate comes from the Restatement of Property promulgated back in 1936. And the restatement tells us that the word estate means an interest in land which is or may become possessory and which is ownership measured in terms of duration. Now, it turns out that while this definition may seem a little dull to you, it actually contains tremendously useful meaning. What do we learn from it? First, that an estate is an interest in land. Now, it's not the only kind of interest in land. An interest may be an estate or a non-estate, and we'll cover the non-estates in a few minutes. But an estate is an interest in land, and in particular, it's one that is or may become possessory. That is, if you have an estate in land, you get to possess it. Now, it may become possessory in the future, or it might become possessory right now. If it will become possessory in the future but isn't possessory yet, we often refer to it as a future interest, and we'll cover those in a later video. Finally, the estate is ownership that's measured in terms of duration. That is, estates can vary in duration. They may be long or they may be short. Indeed, an estate may be infinite in duration, but on the other hand, it may not be. It may last for only a short period of time. Now, estates, as we've said, give their owner the right of possession. But what do we mean by the term possession? Well, we mean more than mere occupancy of the land. We mean more than a limited right of use. The word possession includes the right to control what happens on the land, to build on it, to destroy things that are built on it, to mine the minerals, to take the water. Basically, you might almost say to do anything you want to on the land. So possession means a very, very broad set of rights. On the other hand, the right of possession isn't absolute. It's limited by some fairly obvious principles. First, the law of waste. If the interest in land that we're talking about is less than a fee simple absolute, in other words, one that will last less than forever in terms of duration, then someone else will have an interest to take possession in the future. And if we harm or damage the land, we're committing waste, and the person with the future interest may have the right to sue us. So even the right of possession doesn't include the right to commit waste. Second, the right of possession is limited by the law of nuisance, which is basically a duty not to harm the neighboring property owners by doing something obnoxious on our property that unreasonably interferes with their use of their property. Finally, as everybody knows, land in most areas of the United States is subject to zoning and other land use control ordinances that limit how it might be used. So all of these principles limit the right of possession so that it isn't absolute. Now remember, estates may or may not be limited in time. An estate might be forever, or it might be for a shorter period, or indeed might be for any period in between. Now to summarize then, an estate gives the right of possession either immediately or at some future time. The non-estates, on the other hand, which we're about to cover, never give the right of possession, but they may give more limited rights, such as a limited right of use. Now let's take a look at the non-estates. There are 4 of them that we're going to list here. The first one is called an easement, and an easement is a limited right of use of somebody else's land. Notice that I said a limited right of use. It isn't possession. If it were possession, it would be in the estate column, but an easement is only a limited right of use and not possession. Commonly, easements are given for things like pipelines, power lines, water lines, sewer lines, driveways, or sidewalks. Those are all examples in which you have the right to go on somebody else's land and make a limited right of use. It's a non-estate because it doesn't give full possession. The second of the non-estates is the profit of prondra, and that's a right similar to an easement to go on somebody else's land, but instead of just making a limited use of the land, it's the right to extract some natural resource from the property. For example, it could be a right to cut timber, a right to mine coal, a right to cut turf or grass, or almost any natural resource. Once again, it isn't full possession of the land in question, and so it isn't an estate, it's in the non-estate category. The third of the non-estates is a covenant, and a covenant is simply a promise regarding the use of the land. Now you might think of a covenant or promise as being a contractual right, but in our legal system, if the contract or promise deals with the use of the land and relates intimately to it, our courts think of that covenant or promise as an interest in the land itself. So if you had the right to enforce a promise that somebody made, for example, to use the land as only a single-family residence, you would be considered to have an interest in that person's land. Obviously, it doesn't give you the right of possession of the land, and therefore it's a non-estate. The final category of non-estates is rents, and all of us know that rent is money paid by a tenant to a landlord. We tend to think of it as like a debt. It's a contractual obligation. But once again, in our legal system, the right to rents is considered to be a right by the landlord to a non-estate interest in the land itself. The common law thought of the rents as coming out of the land, somewhat like mist oozing out of the swamp. And indeed, in the feudal period of the common law, that was quite realistic because rents usually were in the form of agricultural produce or commodities. And therefore, to say that the rents came out of the land was quite realistic. Even today, however, rents are considered to be an interest in the land, even though they are in the form of money. Now it's time to look at the estates, and they divide into 2 big categories, the freehold and the non-freehold estates. We're going to start with the non-freehold. Sometimes they're also referred to as leasehold estates, and that's understandable because these are estates that are held by a tenant in a landlord-tenant relationship. There are 3 of them. They're called the fixed-term estate, the periodic estate, and the estate at will. Sometimes you'll see a 4th one listed called the estate at sufferance, but I haven't included it here because it really isn't an estate at all. Now, because these deal with the landlord-tenant relationship, you'll study them in detail when you come to your study of landlord-tenant law, and so we're going to set them aside for the time being here. The freehold estates are divided into two big categories, the fee estate and the life estate. So a freehold might be a fee estate, which means it has uncertain or potentially infinite duration, or it might be a life estate, which is measured by a human life. In other words, it will end when somebody dies. A fee estate is divided into two possible categories as well. A fee estate might be a fee simple, or it might be a fee tail. Now, a fee tail is an estate that was designed to stay in somebody's family through successive generations. And no owner of the fee tail could convey it out of the family for more than one generation. In other words, when that person died, it would come back to their bodily heirs in the next generation. That meant that as a practical matter, the fee tail wasn't useful for commercial development of the land because nobody who bought it could count on having it for more than one generation. In general, the common law courts and the courts today don't like fee tail estates, and they tend to minimize their importance, and in fact today the fee tail is largely disappeared. The fee simple, on the other hand, wasn't attached to any particular family. It could be transferred at will by its owner. Now, a fee simple estate might either be absolute or it might be defeasible. If it was an absolute estate, it definitely would last forever. A fee simple that was defeasible, on the other hand, might not last forever. It might cut short or be terminated by the occurrence of some future event. So a defeasible fee simple estate is one that might be cut off in the future. Now, you'll hear the term fee simple absolute many times in your law school career and in law practice. So it's worth spending a minute to think about what each of the words in the term fee simple absolute mean. Just to review, a fee is an estate that has either uncertain or potentially infinite duration. If it's a fee simple, that's to distinguish it from a fee tail, that is, one of those estates that was designed to stay in someone's family. And if it's absolute, that means it's not defeasible. In other words, it will have actual and not merely potential infinite duration. I like to think of the fee simple absolute as the big enchilada. It's the largest, most extensive estate that's recognized by our legal system. And when people buy land, what they really want is a fee simple absolute. No one goes out in the market to buy real estate and wants to buy a fee simple determinable or a life estate or a fee tail. That would frustrate their objectives. What they want is a fee simple absolute. Now, at the bottom of the chart is the fee simple defeasible, and there are three types of fee simple defeasible estates. I've labeled them FS, but that just stands for fee simple. The first one is the fee simple determinable. The second one, the fee simple subject to conditions subsequent, and the third one is the fee simple subject to executory interest. These are distinct from one another with regard to the words that create them and the mechanism by which they can terminate. But we're not going to cover them in this video. That's the subject of the next ProfDale property video. Now here's the entire chart, so you can take a look at the one you've drawn on your paper and see if it's correct. If it isn't, make any corrections you need to make. It's very important that you memorize this chart. You need to know it backward and forward. You'll find it to be tremendously helpful to you. It will allow you to keep straight the terminology, which is admittedly potentially quite confusing. It will give meaning to what otherwise seem like a sort of random collection of strange words, and it will also help you to see the relationship of these terms to one another. That concludes ProfDale's Property Video 5 on interests in land. The next video, Video 6, will cover the 3 defeasible fee estates. If you have questions or comments, email profdale01@gmail.com. Thanks for watching.